Okay, welcome back everyone. Before I get into the Moat for the last bit of the session, which I'll be doing with Tony as we go down the track, I just thought it'd be, particularly at this point in time, looks as though we're about to hit, as I said, the tsunamis come in, the flood of money, which is going to cost future generations an absolute fortune. And that tide is going to start to run out, and we're going to find who, as Warren Buffett says, we're going to find out who's been swimming naked. So I thought it was a good opportunity. Are you there, Michael?
I am, Grant.
Yeah. Do you want to take people through these slides and cover what their clients can do, just in case? We've talked about all the protection and all that, but if it's too late for some clients, what the best thing to do is.
Yeah, sure. Sounds good. As Grant said, it's fantastic being proactive and reviewing our clients on a regular basis and ensuring their assets protected and using such great tools as what Tim has just shown us. But quite often, in many cases, we deal with a number of clients, and this is a case that we've got up here where it's often that hasn't been done. And it's often too late by the time we get them. And so we have to look at other avenues in relation to what we can do. So I sit as also as a director on a pre-insolvency asset protection business group. And this was a case that we saw recently. It's a North Queensland business, helicopter business. They had about, they've got about 6 or 7 helicopters, strong profits, more than $1 million per year. Won't say the exact number. Good cash flow, however, very crippling debt position. They've taken out a lot of high interest debt facilities from cash flow lenders, other high interest positions with business lenders, and they also had an ATO debt position. In this case, the ATO debt position, the accountant had done the right thing and ensured the client had the client had done the right thing. It's just the accountant had also ensured that they did that and lodged their BAS on time. They lodged their PAYG withholding on time. They lodged their GST on time, and their superannuation was up to date. So we were able to, we'll work with that. Obviously, there's no director liability when it's been lodged on time. So the structure was that there was a trading company only. So all the plant and equipment was held by that one trading company. One of the first things we looked at doing here was the establishment, or whether as part of the strategy, the establishment of an asset holding company and shifting assets across to that. That can work in twofold. Obviously, there's an asset protection piece there. If something happens to the business now as we're dealing with them, if we have to liquidate it, or in the business in the future, as long as we value those assets and any of the assets of the businesses which transfer across, then there's no clawback in relation to that through a liquidation process. It's also, we also often use it as well for transferring assets of the business across for, I guess, as a succession planning piece. Some people can utilize, if they can then sell the underlying business company and then utilize those assets. If you can just flick back on that slide, Grant. They utilize those assets. They keep the assets and then lease them back to the business they sell, whether it's another family member or an external party. So mum and dad were both directors, unfortunately, both in their late 50s. So obviously another strategy there which Tim was talking about earlier, is really having that liability in just one party, not both. So we looked at changing that. There were a mix of employees and contractors. So we went through, reviewed them, make sure that they were contractors, make sure the appropriate agreements in place. There were directors' loans owing by the company to the directors, so the mother and father. Unfortunately, these hadn't been, which we see probably 99% of the time. No loan agreements have been put in place, and more importantly, no PPSRs had been lodged on those loan agreements. One of the things I do for all my clients, and even when we're looking at pre-insolvency liquidation clients, is and there's some timing issues around this, but we look at using loan agreements from LightYear Docs and then for director loans, and then registering the PPSR. So they are a secured creditor to the company. They will rank ahead of unsecured creditors, including the Australian Taxation Office in most cases, and other unsecured creditors. In this case, there was joint personal assets. So we looked at ways in which we could change that between, I guess, the risk and the non-risk party between the mum and dad. And so, some of this is often, I mean, when you've got residential property, it's a matter of ensuring that one party hasn't contributed equity to that property unbeknowingly. They may think that they don't have an ownership stake, but we need to go through and actually ensure that we do the appropriate transfer of property, ensure that they're not holding equity that they're not aware of. The directors had high consumer debt. One of the big areas we also work in is in negotiating that consumer debt. So with the likes of funders, Latitude, and we often get quite good positions. The other day we were able to manage to get, I'm not saying this happens all the time, but we got a Westpac facility on some resi property down from 1.3 million, and they settled for $50,000, which was quite a great result. But we've got a great team behind us working on that. So that company, just for example, is headed for liquidation. They've been advised to go into liquidation. We've managed to restructure the business, and they've traded out of it. And we've obviously got to be cautious these days in relation to Phoenix and everything, but we've managed to restructure them, and we've managed to reduce, I guess, that crippling debt profile and their positions with the ATO, and also secured their assets and put them in a much stronger position. And they're doing considerably well now. So I guess it's always important to look at, you don't have to, sometimes you do have to go down the liquidation route, but quite often, more than not, it's good working with advisors who have the ability to manage the process in terms of asset structuring, succession planning, and that fits in with estate planning as well, and looking at ways where you can work with your clients rather than against them, which liquidators tend to do.
Perfect.
So I've just got a bit of a slide there. We talked about it recently on the strategy summit, but there are, and I know Tim sort of mentioned this, there are potential liquidator claims that could come out of COVID-19 if accountants and advisors haven't been acting in the appropriate way and providing appropriate advice around cash flow and everything. So it's important that if you don't believe you have the necessary training or anything to seek that expert advice, put the right strategy and plan in place. You know, one of the processes we go through straight away is developing a strategy in relation to businesses such as that helicopter business. We work with the accountants or financial planners and advisors. Then we review our options and take action. And as I said, that may involve liquidation, or it may involve revaluing the business, selling the business, transferring assets, protecting assets, and that is really assisted through the ability of the utilisation of documents that we get from LightYear Docs, and working with the accountants and other advisors such as solicitors and other parties.
Well, while we're here, while you're there, let me just jump out of here and take us to the slide on SEPEPA. So you've obviously, we've set up the, you're a director, I'm a director. We've set up the association, which is a not-for-profit public company. So where is it at this stage?
We're looking to set up a working group. So I guess what you and I have spoke about it recently was they'd be our foundation members and build out our strategy around the membership, CPD, and how we're going to run that association. I guess the articles of association, how we're going to build that out, the training we want to do, what it will deliver to our members, and as you've mentioned there, probably looking at early December, if not January kickoff. So that working group will work on even the branding, strategy, websites, logos, and building out that membership group. We've got a large number of members now who are going through and doing our regular training. So this will formalise that training, provide them with certification, provide them as part of the association, and regular CPD and access to other advisors within the network.
So for those of you who really want to get involved in the working group, this is exactly the same process. As I said before, we set up with the SMSF Professionals Association, and I know that we have a look at Sally. She was involved in that process with the SMSF Professionals Association. So if you're interested in doing if you're involved in the working group, I know George Stubbs and a few other people are, just let Michael know, michael@lightyeardocs.com.au, which you'll find in the chat. So if you do that, what we'll do is we'll compile that. We'll probably have a meeting in about 3 or 4 weeks to all sit down and put that down. But it's going to be interesting, I think, from my perspective. There's a fundamental change in the way associations run and show their worth these days. Primarily the associations through their own CPD. CPE were rivers of gold, their CPD, and they'd be very expensive, as you would attest to, Michael. Some of the institute sessions and even the SMSF associations were very expensive. Now they're sort of left out on a limb with COVID. You can't charge so much for online. But now we've got the government through FASEA for planners, the Tax Practitioners Board for CPE, that effectively we've got a position whereby anyone such as ourselves can, and also SEPEPA can offer that CPE. So it's certainly going to be interesting to see how they flow with it. But again, if you're interested, it's michael@lightyeardocs.com.au. So thanks for that, Mr. Michael.
We'd love to have a good group of people on board.
Yeah, no, it'll be a lot of fun. So I'm going to come back and have a look at this Moat case study. Before I do that, Tony, we've got a little estate planning roadmap, which many of you have probably seen before, where we've gone down. For example, one of the ones we had a look at with Sam and also Max Smith. Have I got it there? I think. If we have a look at Max and what's his name, Sam Smith, some of the other issues that were really down on the table is you need to check that BDBN. Is that going to be paid directly to Sam, or is it going to go into the estate? And then obviously that will be up for a trust. Likewise, if it goes directly to Sam, she could settle it into an SMSF Death Benefits Trust. But the only problem there is generally it's the trustee that needs to do that. But you're not going to be able to do that with Australian Super. Now, this is where we sort of get into it. Obviously, insurance is a big issue, starting up an SMSF and stuff like that, and setting up bum clothing into a trust. But look, Max lived with Claire for 8 years before he fell for her best friend, Samantha, who happens to be the current wife. Claire hates Samantha and her life at the right at the moment. So what claim does Claire have on Max's estate? So do you want to just address that one, Tony? So under family provisions, because she's a de facto, she has been for quite some period of time, has she got a claim? So, for example, if Max passes away now, can she make a claim on the estate?
You can possibly make a claim on that estate if it passes through the estate, obviously.
Yeah, definitely. And I think that when you get to something like this, and you'll see we're about to go to Dad, obviously, John Smith, and also Sally Smith. Essentially what we're going to do from there is we're going to start to look at the building of the moat. But in the meantime, there'll be cases like this. And remember, we saw in that letter that's produced for the basic will, if you've got a de facto, if you've been married before, if you're going to leave a child out, we need something a little bit more sophisticated, and it's just a little bit beyond your reach, then that's where Abbott Mourly can step in. So if you have a look at that, where's our little diagram there? There we go. So if you want to explain that one, Tony, exactly the process.
Yeah, so the process is basically, it's pretty straightforward. It's not hard, right, if you follow it. In terms of preparation of data capture, we've already done that. 2 is basically then after the data captures and you input all your data into the LY system, it'll obviously spit out the will. And then once the will has been prepared, then what happens is before you even get to step 3, you got to be able to explain to the client, well, this is the will according to the data capture and what you've given us. You can either take a legal sign off on it, which will bring you then into step 3, 4, and 5. Okay. If the client doesn't want to sign off at the end of the day, you've got to specify to the client, well, then, these are the risks that you're going to take. If it's just, step 1 and step 2, otherwise it's highly recommended at the end of the day that, you set up a time basically with Abbott Mourly. So that way we can go through the will, which gives the client more the advisor and the client a level of comfort at the end of the day for legal sign off. And it's not just legal sign off we're talking about. It's not just a tick of the box basically, right? There's a bit of a preparation there, and I want the advisor and the client to actually take that journey with me to see how the Zooms are prepared, how I take them through the document, how I take them through the execution process. So there's a little bit there, basically. So with the first Zoom, and I've done this previously with a number of other clients, where we've jumped on the first Zoom, we've had a look at the, we actually had a look at the will or the Moat together, because I share the screen with them. And I take them through every step of the way and every document basically to make sure that what's in that will is correct. 99% of the time, the client will come back to me basically during our Zoom conference and say, Tony, this is what I want changed, or these are the amendments that I want changed. So we take all that back basically. We then redraft it because the client has engaged me now. And then we do a second Zoom after that to make sure that the amendments or those requirements or the amendments that have been amended conform basically with the client's instructions. And then we go on to step 5, and then we get into the execution process. So I really want the advisor and the client at the end of the day to come through this journey with me to see what it's actually like at the end of the day. And it's pretty exciting at the end of the day when I jump on with the client and the advisor to take him through that whole process with me. And that way the client and the advisor, or more particularly the client, gets value out of it. He's seeing value at the end of the day. So that's the general, that's the roadmap to it. So you have 2 Zooms at the end of the day, and then after the 2 Zooms have come into play and the amendments have been done, then we take it through the execution process basically and finalize that will. After the finalization of the will has been sorted out, then the actual original wills usually get posted back to me. I sign them off because I've witnessed them on that day. I sign them off on that day. And then what I do is I send back the original wills, depending, it's subject to the client's instructions at the end of the day, whether he wants me to keep the wills, his original wills or her wills, or he wants me to send back the original wills. But I always make 2 certified copies. That is, one for my file, one for the advisor's file, and the originals go back to the client at the end of the day. So it's a little bit of a process, but we get there. So
I think importantly, up the top there is, these are the fees that we charge, but this is typically what a suburban lawyer would charge. Tim's obviously got his charge out rates as well, what he charges for the different things. But we've got this as sitting up on our strategy center. You can see there for the uncomplicated wills, if you remember the SAM and also the Max one, we may well not need to have sign off there. But once you've got one of those ones where you've got a de facto, you've got a child left out, a disabled child, that's definitely where you get Tony and the Abbott Mourly team involved. If it starts to get deep down into SMSFs, then I get involved. But the costing there for you is it's $495 for a single will and EPOA, and also SMSF will, and $895 for a couple. So you can see there's still plenty of margin in there from your perspective. Which is completely different to what happened before, is that you refer to lawyers, they charge all the fees, take ages, but really you're in control and obviously set Tony's time up. But essentially you can see with that EPOA and will, it doesn't take that long. Once you get those common parties, and we'll put that in, David Rutherford will definitely put the common parties in and we'll take it from there. So that's essentially where we are at the moment. Do your numbers in terms of working out if you did this, how many you did per month, and start to work through there. So let's have a look at this case study, and it's not super sophisticated. I haven't put in too many bombs in there, but look, I've got John Smith, is a 60-year-old doctor with his own practice and also a locum at 2 local hospitals. I'm not going to focus so much on self-managed super funds at this stage, but I have got all the solutions there for you in these PowerPoints. So this will be out later today, but he operates via trust. John wants to retire in the next 3 years to go adventure traveling with his wife, Sally, a 40-year-old charity worker, and his second wife. The first marriage ended acrimoniously and with many a threat to take John's fortune. So as soon as you see that, obviously, there's a concern there in relation to making sure that you've got good SAPEP or asset protection around it. And if I saw something like that, I'd be sniffing out the protector straight away, as Tim was saying. In Kelly versus DeLucci, Kelly had 3 spouses. One was, in fact, a Filipino, a bride from 27 years ago. He was married to ostensibly for 2 years. They couldn't find the lawyers. The no-win, no-fee lawyers tried to locate her, but couldn't do so. But essentially, it was quite funny because, notwithstanding that, because obviously the more defendants they have, the bigger their fees, because they can actually represent 2 parties rather than 1. And at the end of the day, they couldn't find the ex-spouse from 27 years ago. And it's funny because it was actually raised at the court that not only she had been married 27 years ago, but the marriage was null and void because effectively she was already married in the Philippines. So, but again, she still had that ability to claim under the Family Provisions Act. So they got John and Sally have investment properties worth $2.2 with $300,000 in debt. So they've got effectively net equity there of around about $1.9 million. That's in their own names. Obviously, they've been using it for negative gearing purposes, given his high income. Obviously, we prefer to have it in the trust, but they haven't done so. In SMSF with $1.4 million in his lump sum account and $1 million in Sally's account, with John and Sally as trustees. We won't go into that to any great extent. Can you believe Grant Abbott saying that? He's not going to focus heavily on SMSFs, but I have given you solutions. They live in a $2 million property in Toorak Gardens in Adelaide with their disabled daughter, and the house is owned jointly with no debt. John and Sally have 3 children. They've got Max, who's a successful stockbroker, chip off the old block. He lives in Sydney with his wife, Samantha, and 2 children, Catherine and Janine. We've already seen those, but I think it wasn't the stockbrokers in construction firm anyway. Sarah, who's estranged from her father, and is the 32-year-old doctor working country New South Wales. And they've got Jodie, who's 21, as the disabled child there. So we've got potential litigants from a family provisions claim of Sarah and obviously the ex-spouse as well. John completed a will with his family solicitor in 2010, giving all of his estate to his former wife. So that's null and void, and a BDBN directing the trustee of the fund to transfer all his super to his estate. The executor of the estate is the ex-wife. So effectively, the whole thing is an absolute nightmare, really, when we come down to it. So there's a number of things that we look at doing. And when we get a client like this, and I'll probably go back to where Phil does, we do this quite often. Tony and I will have a Zoom meeting with a client I will go through the whole process of setting up the Moat directly on the platform by having the video. So the Zoom video, Tony has a chat with them. I ask them questions, and then we build the Moat together. Now, there's plenty of documentation around the Moat, plenty of videos there. I've done deep dives for our members. I did one a couple of weeks ago, which was a really quick one. It's fantastic. So I won't go into a huge amount of doing the Moat. I'll talk about the understanding of it and what we've done. We've already seen part of the Moat, essentially being the will and testamentary trust. Now, what I found is that when I first started doing this from an estate planning perspective, what I found is that I would be doing a SMSF deed upgrade. I do a constitution upgrade, and so I'll just show you where it all is. So I'd go in here, and I'm upgrading the SMSF to a leading member style. So I'd choose this leading member kit, upgrade of SMSF deed and corporate trustee as well. I'd be doing a protector, and then effectively I would then be going down, if I had a look at the trusts here. So he's got a family trust. I'm not sure whether I'd make a change to it, because the only thing in there is obviously his business, which isn't too bad, but at his age, if he's looking at retiring, I could go down the leading member route, but it's not the core. It's not the core thing. And if I'm going to throw a protector in, I'm not going to use that trust, because there's potential, obviously, litigation. Anyone who's adopted has got potential litigation. So I could, if I wanted to, do a leading member discretionary trust variation if I wanted to. And then there's another document where I can upgrade the deed as well. For the SMSFs, I would obviously look at the pension side and that. But I found that I'd be going around, bouncing around, doing an EPOA here. I'd go up to this document here. Okay, I'd stay, well, I'm doing an EPOA and for New South Wales, then I'd be doing a will there. And you can start to see that we've now started to blend the whole lot of documents together. And so where we are today, effectively, we've got if I can find it. Okay, so if I look at the Moat, I think I've already got that one open. Nope, no, it must be there. No. If I have a look at the Moat here, and I open it up and I launch it, I think I did launch it somewhere. I must have closed it out. So I found it took a long time. And likewise, if you went and you said to a lawyer, okay, even if they understood what was going on, that I want to get an upgrade, you couldn't even do it anyway. Even if they did and they had all the precedents, they had everything, it's going to take weeks for them. You know, once you do wills and all that sort of stuff, upgrades, and you start doing it, documents and Word doc, it becomes virtually impossible. So what we've built is this strategy automation, which the technical term's called robotic processing automation. Now, the system we're using here is widely used in-house by more than 1 million legal firms around the world. So it's a very robust system. Those who look at it, but it's not the prettiest system in the world, which is why Michael and Ashley and the team are going into that LightYear Docs 2 to enable us to up the ante and make it even more automated. So that's our skill, because at the end of the day, if we can provide a compliance proof, but also minimize to the best of extent as possible that data capture of those interview questions and ticking boxes and all that, then at the end of the day, we can produce a really good product at the end for your client in a quick amount of time. And quick amount of time means that, honestly, I could sit here and go through this whole interview question with a client, and at the end, I'd be able to produce all of these documents at the end of the question. But as Tony said, it's just too much information for them. So I've got the common parties here. I've got John and Sally. I've got William, Marie, and Max Smith and Janine Smith. Where did William come in? And then I've got Kathy Smith, both of those ones. Oh, William is the brother. The other one I'm going to have to put in there. So we've got Kathy Smith down the bottom there. And I think I've got John Smith living at, okay, Unley Park in Adelaide. So I go down to Kathy Smith, and then we're going to put in an individual. And then I think, who did I have quickly? The daughter is Jody. So I just need to put, again, Jody in there. I agree, David, it'd be great to have some common parties in there. So I just jump in here, and I'm going to put Jody Smith. She's at 5 Whistler Street, and that's at Unley Park. And I think that's 5061, if I remember correctly. And then we've got South Australia. Now, what I'll do is I can add another one here. I'm going to add a company. I'm just going to call this SMSF Nominees, Pty Limited, and then I'll just put in the ACN. And then we'll just use, we'll just put it 5 Smith Street, Adelaide. And so this is at the accounting firm, South Australia, and that's 5,000. So I've done the common parties, and look, I can put, for those of you who saw the session, I did a deep dive, a Moat of Travis, who's our relationship manager. He had 15 different common parties, the most complex one I ever did, but I ended up knocking it out in an hour. So the company directors at the moment, we've got 2+. This is for the SMSF. But remember, I could have an EPOA if I want. So I've got John Smith and I've got Sally Smith there. Now, obviously, one of the ones, I'm not going to do it now, but one of the ones I'd be doing effectively is ensuring that probably not Sam Smith, but Max Smith ends up in this family SMSF. And obviously, Jody should also be in there. One of the key criteria, I won't have time now, but what I'd be doing is I'd be building a auto reversionary pension going from a John to Sally, then to Jody, because as a disabled child, effectively she can receive that income stream from the superannuation fund. So she's the second reversionary, and that's just an account-based pension. Even though she's a child, it doesn't stop at age 25. So what I need to do is I need to go through and have a look here. Now, they've got a lot of exposure there for their current assets in their own name, being their property, which is $2 million. And remember, those 3 investment properties were around about 1.9. So ostensibly, we're looking around about 3.9. And being a doctor, no doubt he's got a pretty flasho car. So you're probably looking around about 4.1 in terms of the net equity. So I don't like exposure. We've seen Tim talk about it. You know, my preference is we're going to do the protector. As you can see, these are all the documents that effectively are incorporated into this one Moat. So it's our comprehensive estate planning package. So I'm going to do the protector. I'm also going to do the EPOA, and he's in South Australia. So I'm going to have a South Australian one. So you've already seen me do this. If I haven't got a SMSF and I want to set one up, you can actually set one up here at the right at the outset, but we're going to do that. They've got an existing SMSF, so I'm going to go through, I'm going to upgrade the constitution to a leading member. I want to show you what that does, because if I can show you there, that will also flow through when we're doing leading member discretionary trusts or family protection trust, which is just a simple way of doing that. I'm going to upgrade the deed, of course, to leading member. I'm going to do an SMSF will, and then I'm going to do my last will and testament. And likewise, we've got exactly the same. So are you accountant, blah, blah, blah. And then we go down here and we haven't got the firm. We'll just put in there Blake's Accountants Adelaide. So that is obviously the Smith Street in Adelaide. So we're going to go down there and I'm going to start building all of this. So you just put it in. So I've got a question with the, so if I have a look, okay, so when I have a look at this, someone's asked me a question, does the digital assets, are they included in the Moat? I'm pretty sure they are. But I'll go through. So let me just have a look here. Yes, so we've got the digital assets there. So you can go through and have a look at that. So what I found is that I got super frustrated because I'd have to go in, copy paste, pull another document. And honestly, it would take me a day to do something for all that. But then I started using this, and I'd be talking to the client while we're going through. The main thing is to make sure you've got all those common parties up front. And when you've got all those common parties, you're in a pretty good position. One of the ones I want to show you just pretty briefly before we get in there. So this is the first one. You can see it's very SMSF inclined. One of the ones that I have got, so I'm going to look into our LightYear Docs system. So this is the back end. This will change going down the track. I look at my work items and then I should have, let me just see. Okay, so I should, I think this is, yes, the Moat and the Castle. So when you have a look here, I just want to show you, I've got another one coming down the track, but I've taken you through the basic EPOA and will. So you're on top of that one. Then what I would be doing for the client, and if I go through and show you, so this is the next level up. So this is the Moat and the Castle. So you've got the Protector, the EPOA, so it's okay. And we've got all the SMSF stuff that we saw before, but we've got a few extra. We can create a discretionary trust or leading member, or we can actually upgrade if we want to the trustee company and the discretionary trust. So because I've got this, I'd probably be using this system for Max. Does that make sense for everyone? We've put up onto the system now the Moat, which really encompasses so much there for the client. I want you to get used to that before we then move to the Moat and the Castle, unless you pressure me, and then I'll put this up, because not only does it cover all the discretionary trusts and build a family protection trust in the Protector, but it also upgrades the SMSFs and does family allowance and dependent declaration, so that if your client is making a regular stipend to a family, such as their adult children, potentially they are dependents, which means when there's a passing of benefits to them from the self-managed super fund, either by way of an SMSF death benefits trust, which you'll see in the SMSF will, it'll come out tax-free. But it also enables us, if they've got existing pensions, to roll them back and then put in that reversion, for example, with Jody. So you can see it's just a lot more, no, I shouldn't say complex. It's just got a lot more automation in there for us. And I think that is absolutely crucial from okay, so everyone wants it. Okay, thank you very much. What does BDBN stand for? That's a binding death benefit nomination, which essentially I should get rid of that. It's just an SMSF will. Okay, so I'll put this up so that we can look at that next week. I'll just go through the Moat pretty quickly. But if you had the Moat and the Castle, essentially for someone like Max, it enables you to do absolutely everything you can do. And I'll go through for just about 10 minutes or so, because I want to wrap up and go through things. I'll go through 15 minutes, see how far I get. So it's now, I'll just wait for it to tick over 11:40. And as soon as it ticks over, I will then start getting into it. But the Moat and the Castle is look, what I'll do is I'll promise to launch that. It's now the 14th of October. So I'll launch that on the 1st. I'll launch that on the 1st of November for us. So that's the Moat and the Castle. So if you haven't got down that, if you're going to do your own stuff, do this here anyway, which is not a bad idea. And we'll wait for the 1st of November. You can see I'm just doing a little padding, waiting for 11:40 to come in, so I can show you how fast it is. Now, mind you, I've done a few Moats before, but I can tell you the time I get in 10 minutes into this compared to 10 minutes just trying to do a couple of documents is virtually impossible. Okay, so let's go through the enduring power of attorney. Now, this is a South Australian one, so I'm just going to choose John Smith. Don't need to put in the dates because that's obviously going to be a little bit later on. We've got the individual. We're going to put Sally in there as well, so that's okay. We might just take a bit of pressure off her, and we'll go from Sally, and also we'll have Max, which is the son. So they're going to be joint attorneys. Now, if they're not around, are we going to appoint a replacement attorney? Absolutely. Is it going to be joint? No. Would I put in Marie? Well, no, she hates her dad. So I'm going to put in William there. So William is the brother. So this is why we put that in there. So if Sally and Max is not around, then what we're going to do is we're going to put William into that. Now, I'm not going to put any further from that one. Now, the power of attorney, this is in South Australia. I'm going to put this in. They've got an SMSF. Do anything on behalf, personal and financial, absolutely. And also going to put a successor director in there because they've got a corporate trustee for their superannuation fund. So I'll click that one as well. Now, when's it going to be effective? So upon execution of the deed, and then how the attorney is going to act, and I would say jointly and also severally. So we've got no boxes out of there, so we're off and running. So now we put in the company there. I've already got that details in there. So that's all the common party. Got the current director's names. So that's fine. And I can add another one if I had that there, but these are the only ones I've got. So you can see the more I put in there, the better. So that's it. I've done the EPOA and I'm now 1 minute in. So now I'm going to do my the Smith leading member SMSF super fund. I just want to make sure you guys have got plenty of time for a question and get a wrap up from the guys at the end. I've got the trustee, that's pretty easy. We've got the company, don't have to do much there. SMSF nominees, so that's all punched out from there. Constitution upgrade, so we're upgrading it to the leading member. You say, well, why would you do that? Well, the leading member one, again, they control and they can hire and fire the trustees. Importantly with the leading member, though, is when we come around to do the leading member, that's going to be John. If something happens to John, we'll then pass it on to Max. So his shares in that company are automatically cancelled. So we go down there. So that's okay. We have the meeting. What we need to do is have the shareholders have a meeting. My preference is when you are, if you've got a special purpose SMSF, just have one shareholder. It makes it a lot easier, particularly if you're going to upgrade the leading member as well. And the skill is obviously to have that really strong line of succession like the royal family. Is this a joint leading member? No, you can put it in if you want. So the first one is going to be John Smith. Is there a second leading member? Absolutely. So we go down to that. I'm going to make it Max there, which is fine. Is there a third one? I'd go, oh, yeah, okay. So who's the third one? Obviously, it's not going to be Marie or Jody. So what I'm going to do is bring the brother in, William Smith. But I'm not going to have a fourth one. That's enough. So upgrade of the deed. So we're in South Australia. We're going to upgrade it. We don't know the date. When was the fund originally set up? So 01/12/2012. Has it been varied in the past? You can just, if it go yes, you could be as many variations you want, but I'm going to say, well, they haven't varied it since this time. And you'll find, I just put up an email yesterday that you can send out to your client database on suggesting or recommending that they upgrade their deeds, particularly if they haven't done it for the last couple of years. Because look, my deed's super fresh, includes all the 6-member rules, includes living wills, all of these strategies we're doing for, you don't want to even try this on another deed. Okay, the deed of variation, I go in and find out what the clause is. 41 allows the trustee to amend, so I don't need to get the sign off from the founder, leading member, or another person. If I do, I just have to tick yes, so it's going to be no. Okay, so far I've done the power of attorney, I've upgraded the constitution, I've upgraded the deed, and I'm 4 minutes into it. So now I'm going to go to the SMSF will, which is, we call it a binding death benefit nomination, but it's just a really sophisticated one as we go through. So I'm going to select the party. That's pretty easy, John. Unfortunately, at this stage, the moat and the castle, I haven't got, being able to do joint EPOAs and wills and SMSF wills, but I will be able to build that, and we are going to have to put in advanced healthcare directives. The goal there, if you understand, is this is a one-stop shop for all your clients. You know, all the stuff that Tim was talking about in that letter, you can do it all in this one interview. And once it's in the system, it's in our vault, and you can go back. If, as I said, Sally, leaves John, then you're off and running, can basically go off and do whatever you want. So there's 6 buttons here. Do you want to revoke earlier nominations? Yes. Do you want reversionary pensions to take precedence? Yes. Does it mean we want to appoint the executor? Do you want a professional look after? Absolutely. So then we go down to death benefit payments. Is it going to go to the estate? Well, not on my watch. So then we've got the beneficiary here is Sally Smith. So that's the spouse. And then what I'm going to do is give her 25% of my superannuation. Now, if she's not alive, is there a succeeding? Then what I'd do is I'd make that, say, Max Smith. So that's fine. And if Max is not alive, then what we do is we put it into SMSF Death Benefits Trust. Now I can add another here. So what I'm going to do here is my beneficiary is Jodie Smith, daughter, and then 75% of my superannuation interest as an account-based pension. Now, is there a succeeding beneficiary? Yes, if she's not alive, then we're going to punch it back to Max Smith, and then it goes to his children. So that's our SMSF will nominate a professional. I don't think I had the parties there. So we're going to do it. I forget, what did I say? I forgot the name of the accountant. So please give me that one. I'm pretty hopeless sometimes. So you want to make sure you put that in. So we'll just call it John Blunt. Let's say it's going to be 2% of my superannuation estate as administration fees, because you will be setting up SMSF Death Benefits Trust, etc. Select the firm as Blunt's Accountants, and then that's in 5 Smith Street, Adelaide, South Australia, 5,000. So I've done that. I'm running out of time here. Okay, so the meeting, we've got John, Sally attended, John was there, the address. I'm trying to get this into all of our systems because it's a great one, but I'm just working out how we do that. So that's at Whistler. So now that I've done that, last will and testament, which you guys have seen already. We've got the test data running out of time. Let's just go through really quickly. I've got John Smith there, professional advisor, accountants. I then go through the executor is going to be, might make this Max this time, and that's the son, rather than having the spouse, successor executor, might make the brother, William, second successor, yes, and that's where we might pop in Sally in that instance there. Third successor, nah, that's a bit overkill. Principal beneficiary, we go through again there. So specific gifts, we can go down in this one. So would you like any specific bequest here? We might just go no. Specific gifts, now this is the interesting one. The principal beneficiary, we're going to make it Sally, and she's the spouse, and she's going to get 100% of the estate. Now, if she's not around, then it's going to be paid to the secondary beneficiary. The secondary beneficiary, yes. Then what I'm going to do is pay that to William, and sorry, not William. That's the. Actually, I'll make that up. That's the brother. Actually, what I'm going to do, you're going to find out. Hopefully, some of you smarties will actually. See, so we're going to put the daughter, the estranged daughter, and she's going to get 100% of the estate, the remainder of the estate. Now, if she's not alive, then it's to be paid to any bloodline beneficiary. Tertiary beneficiary, we'll say there's none there. Specific gifts, no. Digital, I'm going to go no. Child guardianships, obviously a no. Pet guardianship, I'll go a no. Funeral wishes, Yep. So planted at Adelaide Golf Course. So that's a bit tragic, but anyway. Okay, so I've got that, and now you're going to find. So here I am. Here I've done is given Marie, show Marie the will. But you're going to get all of this sort of stuff if Sally's not alive and Sally's a second spouse. I'm not going to show you what to do. Okay, so what I'm going to do is the protector. So I'm going to do the protector. So would you like to establish a trust? Yes. I've got to do a solvency certificate, a deed of gift, promissory note, loan agreement, and mortgage deed and personal guarantee. So I'm going to do all of that. I might just save it while I'm here just so I don't lose everything. Okay, so we go down to the, so this is the Smith Family Protection Trust. So this is actually the key document out of everything apart from the SMSF. Select which state. It's in South Australia. You don't worry about the vesting, paying it to whatever. Select a party. I'll just get William there to be the settlor, and he'll put in $10. Okay, so we've got the trustee is a company. So what I'll do is I'll assume there that I've set up another one, Smith FP nominees. So that's a special purpose leading member company. So we'll just go through there. Then we go 5 Smith Street. And that's in Adelaide. So that's a Blunt's Accountants, South Australia, and that's 5,000. How many directors does the company have? We've got 1 sole director, and that's going to be Max. So Max, it's going to be John Smith. Now, what we'd have to do is I would go back and obviously include this in the EPOA so that Max takes over. So the leading member, is the leading member appointor? No. The leading member is an individual, and it's going to be John Smith. Okay, so I'm not going to do a second leading member. In the event of incapacity, yes. Is it joint? No. It's going to be William Smith. Oh, actually, sorry, Max Smith. And then I'm going to go, in case they're there, I want to get some longevity there. So my third leading member appointor I'm going to make is going to be William Smith. And I want to just put it in. I'll just put Adelaide so I don't have to type it in. And then there's no further one. So the potential beneficiary, is the spouse going to be one? Remember, she's the second spouse, and so we're actually excluding her. So I'm going to go no. Is there any bucket companies? No, because this is just a family protection trust and there's no charities. So the accountant is, again, it would have been a lot easier. I forget what I called him. John Blunt. Blunt Accountants. We're looking at a new system when it's going to make it so much easier. I'm getting close, guys. I'm rushing it here. Adelaide. So that's your solvency certificate. South Australia, 5,000. And then we've got the gifter. So what we're doing is we're gifting the house that they both own. So it has to be John, and also we've got Sally. So that means that's now gone. So they're getting rid of their investment properties, their cars, and also their house, the equity. So the giftee is, again, it's exactly the same. It's just John. Add another. It's going to be Sally. Now, I suggest you want to watch this a couple of times anyway. The gift, remember, it's going to be in South Australia. It's going to be cash, and it's going to be a I think I said $4.1 million promissory note. Okay, so we go down to the promissor. So we've done the gift. So the promissor is pretty easy because it's exactly the same as the gifters, obviously. So we've got John, and then we add another. And then we've got an individual, so it's got to be Sally. And then what we do is then the promissee is now our family protection trust, which I should go, if I was smart, I'd go up in the common party. So Family Smith Family Protection Trust. Remember the one I set up. I've got a company, which I haven't got there. So it's the Smith FP. So it's Pty Limited, almost there. So it's 5 Smith Street. Oh, so caps off, Adelaide. I know. So we'll get around to making this a lot easier, particularly if we can pull a lot of information from everywhere. John Smith. And remember, if something happens to John, then automatically he gets kicked out. He can go bankrupt, or if he gets divorced, then what happens is it passes over to Max straight away. Details of execution, it's going to be in South Australia, and let's say it's for the life, we'll do it 20 years for the last beneficiary. Remember, the beneficiary is all the kids. So the promise details. Okay, so obviously it's going to be 411. Okay, that's it. Any payments? No. And then we go down to, we've done the promisor, and we do the lender. The lender's obviously going to be the trustee of the trust, and it's going to be the Smith family. As you can see, I should have put that straight in before, and it's going to be a company. Smith FP. I'm getting there, guys. I'm getting there. Just wait. 1, 2. Okay. 5 Smith Street. Sorry. So I'll have a chat with our developer to see if we can pull this in. So the sole director, and then we go down to John Smith. So you can see at the end, what's happening here is although we've given in the estate, the borrower is going to be the individual. So it's easy as John, add another, and then Sally. So we've given Sally and also Marie, the recalcitrant child, we've effectively given them the will, but there's nothing in the will, if that makes sense. Date of commencement of the loan, where it's going to be, South Australia. Fixed principal loan amount is 4100000. Loan term, 20 years. Last beneficiary. What's a commencement interest rate? Just put in a little one, just so it's consideration. Interest only, all interest payable at the end of the loan. Do you want to do a guarantee? Yes. Then do we want to do a mortgage deed? Yes. So it's getting really busy. So then what I do is, you can see here with the real estate property, I'll only do one, but I'd have to put in the 4 different properties that we've got in there. So lot 50 Unley Park. Then obviously the street address, I'd put in, just go back, where's the street address? I just have to find John. Where is John? There we go. Okay, cool. And go down there. So we've got the registered mortgage here, and I just need to put in that. Park. That's right, only Park and South Australia, and that's 50, let's say 61. So that's it. So it took me a little bit longer, so sorry 12, I'm going to be about another 5 minutes, but essentially I've finished that. So that's all those documents done. I won't go through all the documents. If I did the moat and the castle, it would probably take about another 10 or 15 minutes out of that stuff. Are you there, Tony?
Yep, I'm here.
So with that process, obviously, when we get all these, we've done it in the past before, but you don't recommend sending all this off to the clients, just sending it off in separate documents. Otherwise, it's too much for them to handle.
So we'll do it in little bits and pieces, like EPOA, SMSF will, and the last will and testament is one. So we can run through those. That's fine. You settle those documents up, and then you move on to the next lot basically, and get all that done.
So you can see
stages.
Yeah, so you can see you send off the EPOA, then you go through the SMSF a little bit later on. SMSF will, last will and testament, and then you've got the protector. I would probably do the EPOA first, and then I would probably go down and do the protector. So you can see with the protector, I've got, that's my gift. This is my family protection trust. Okay, so that's the last will. And then we go down here, blah, 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 blah. Okay, and then the next page. So it should be the protector, which then if we go through the protector, has got the family protection trust, which we set up as part of it. We've then got the accountancy certificate or the solvency certificate that we had a look at. Where's that there? So that's the solvency certificate, deed of gift, mortgages, all of that sort of stuff. So if you have a look at it in total, I think there's around about 18 documents that are sitting in there from the resolution. Remember, we went back ages ago to the resolution. So it's quite sophisticated there. We've got a couple of questions. So David, does the Moat allow for change of trust for name of trust or SMSF? Again, whatever's sitting on our system, we can actually build in there. So I'll leave the Moat and the castle. I might put all the changes stuff in there as well. You have to put advanced healthcare directives. Brad, so this will be interesting. If you do the Moat now, no, unfortunately, you can't pull it over to the Moat and the castle. So maybe just wait for a while. I might even sneak it in next week if you like. If the SMSF has pensions with reversions, etc., already happening, and we do a Moat with SMSF deed upgrade, do we need to be aware of watch anything? Now, you'll actually see as part of any deed upgrade that is specific as the operative provisions of the deed upgrade or variation is that it does not impact pensions or SMSF wills that you've got there originally as well. From Sal, transfer of assets to the protector, including, so what we're doing, Sal, is we're not actually, as Tim said, we're not transferring the home. We're not transferring the investment properties. All we're doing is transferring the equity by way of a promissory note, which is equivalent to cash. And that's then lent back. So the individual, the good thing about this is the individual still ends up with the assets in their own name. If they sell it, they'll get a CGT exemption. One of the questions we get is, well, what if we want to upgrade our house? Well, what happens, just like the bank, you've got the registered mortgage, as Tim said, you'll see the settlement proceeds. They will then be banked into the family protection trust. And at that important time, you'll then go and do another loan if they then want to go and buy another property there. So again, there's no CGT or stamp duty. That's why I think the Moat is actually it's probably the best thing that you could actually have around that one. And Tony, did you want to have a chat about that one as well?
What's that? Sorry, mate.
Do you want to have a chat about that one? You're having a look at future CGT if the property is sold, etc. So that's not swept up in the family protection trust. The future CGT for the properties actually ends up with the individuals concerned.
Yeah.
But that's an interesting point.
Yeah.
In the case of divorce, how are the assets in the family protection trust treated? Look, it can't guarantee anything, but certainly if it looks as though separation, John would resign as the leading member appointer or the leading member family protection appointer. That then passes down to Max, and as a consequence of that, John actually ends up not being a beneficiary of that trust at all. So again, you can't guarantee, but it's certainly going to help down the track as well.
And also, Sally, just to answer your question, sorry, I deleted it accidentally. No, there's no stamps or CGT in relation to the protector at all, because all you're doing is just transferring equity across. Basically, you're not actually triggering what's called an A1 event, which is a disposal of an asset, basically. So there's no assets that have been disposed. All you're doing is transferring the equitable interest from the individual into the family protection trust. Yeah.
Yeah. So I've got another question here is we haven't then put in those EPOA's wills and also the EPOA's, the wills and also the SMSF will for example, Sally, which would make it sense. Ultimately, you'd be able to do this and you'd have like 50 or 60 documents, including obviously you'd be able to do wills and EPOAs for Max, for Jody and all the other, people involved. So we've built the Moat in the castle, and I will get it up so you guys can play with it. It has been tested. It's got everything. I'll go through and test it on the weekend and probably get it up next week and let all of you know, because you've been through this course, you understand. But there's again, you can put in. I'm just concerned for you guys is that I don't want to put too much in there and then blow your brains to pieces. But anyway, the main thing there is, look, it's got everything in there, including the kitchen sink. But you can see here that if I wanted to, I can go back in. I can say, okay, oh my God, Sally's now left. And then what I can do is I can go in and change all the documents. I could just go back into my document storage, my vault. I can go to October Strategy Day and I can relaunch and I can then go and make any changes whatsoever. So as you can see, it's a brilliant thing there. But look, we're sort of out of time now. This is being recorded. But Tim, have you got any parting words for everyone?
Hi, everyone. Look, my big recommendation, jump on board, do this for yourselves and your families over the weekend. I'm just going to fire it up and actually do it for us tonight. I've got to have an operation on my sinuses Monday next week. So,
oh, you poor bugger. Oh, that's terrible. I heard that.
Yeah, but I've got a really good doctor, which is great. So I'm going to update my Advanced Health Directive and use this opportunity to update everything right now. My wills, the whole lot. Hey, just a quick question. Does the Moat include the resolutions for single director companies?
Yeah, absolutely. So if I went back to having a look, where did I do the bloody Moat? Okay, so deed of gift. Remember we had that trustee company? We did, and we probably go up a bit further. I've got the SMSF. So I'll go back to my EPOA.
Because this is a massive thing that everyone listening to this today, just that one little thing kind of triggers off everything else that needs to be done. Oh, great.
Okay, so there you go. So it's a resolution by the company to appoint a successor director in the event of the director's incapacity or death.
Fantastic. That's brilliant.
Yeah, so that's what it's saying is once you start to have a look at how many documents there are, it's crazy. And you have to, you either do it one or two ways. You either send it out to clients in a small things, but when it comes around to signing, you get into that big flash boardroom table. You've got Tim and lay out the 20 or so documents and go through and explain it to each of the clients so they can see the things. Advanced healthcare directives, absolutely. So I'm just finalising all those off. They've been the toughest one, but it'll include advanced healthcare directives and enduring guardianships as well.
Hey, Grant, just a quick question here.
Yeah.
Can you set it so the page numbers start back at 1 for every document?
Yeah, no, I saw that one. I'll have a look at that one. I'll have a chat with our guy and also have a chat with Mick as well around that one. Have you got any parting words there, Mick?
That we're just adding to that. There have been a couple of feedback comments which I've picked up off the chat, which is fantastic. So as you mentioned at the start, we're always about being an ecosystem of continual improvement from all of our members and supporters and stuff. So we only continue to keep getting better and better through such feedback. So we'll take that on board and see what we can do, whether it's in the current iteration or LightYear Docs 2.0. But there's a great, awesome presentation, Grant. And
thank you for everyone as well.
From Tim and Tony.
Yeah, and also you, Mick.
and great set of documentation, and the importance. We've got these great strategies, but it's important to back it with the best documentation available.
And Peter Holt down in Melbourne, we are looking at making an easier system for registering mortgages. I know Tim does it up through a solicitor in Gold Coast. It's only $50, but I'm sure you're paying a lot more, particularly the Melbourne solicitors. So we'll be able to get PEXA, which is an online registration process. So we're looking at doing that. We've been very lucky. We've got someone who worked in a legal office down in Warrnambool, who's had a lot of experience in that. So hopefully we'll come up with that a little bit later on. But look, we really appreciate all the time that you have given us. Keep in touch. As Tim said, we're not out there giving floss information like crap that you see that comes through the emails. With our training, the training is for a strategy and a purpose and the documentation. So everything is great, and it's great to have Tim on board, who then gives you that value pricing. So, you can see now the protector is what we've done with that situation. Effectively, we've been able to do up a brilliant will for Sally and to a great extent Marie. But at the end of the day, they're not going to have anything because all the major assets are sitting in that family provisions claim. So you just got to make sure the executor there is really on board, because what they've got to do is, obviously, remember where I had a look at the will earlier today, is pay off that loan. Anyway, so I'll stop now. I'll stop recording, and then what we will do is I'll have this up a little bit later today. But thank you very much. Thanks, Tim. Thanks, Tony. Thanks, Mick, for all your great comments. And also thanks for our team back at LightYear Docs as well.
Thanks, Grant.
And also, just one more thing before we sign off. Don't forget, November, we're going to look at administration of estates, which is 101.
Yeah, so that's a great one. Tony's done a great infographic on it. So thanks all, and have a great day.
Thanks, mate.